that you might have. So if you have questions throughout the presentation, you're more than welcome to write those questions in the chat box, and then Nikki will be assisting with those questions. And then I will also be able to assist you with the questions once I'm done with the presentation. So without wasting any time, I will now share my screen. Nikki, if you can confirm for me, if you can see the presentation on your side as well.
Good morning, everyone.
Hi, Nikki, can you see the presentation?
Yes, Sinabasa, I can see it. Thank you.
Thank you very much. So I will be switching off my video for the remainder of the presentation so that it doesn't disrupt our connection. But as soon as I'm done presenting, I will switch it back on again. All right, so today we're going to be discussing wills and beneficiary nomination forms. But before we even start with our presentation, I would like to just inform you that today's session is not to be taken as financial advice. It is factual information regarding this topic. Should you need financial advice, then Alexander Forbes can provide you with a financial planner or a financial advisor who will be able to assist you. So you can have that one-on-one session. But today we are having a general discussion regarding this topic. And as I've said, please do engage with us. Ask as many questions as you would like to in the chat box regarding this topic, so that when you leave today's session, you have a better understanding of all the benefits you have, how they would be paid out, and what the role of the beneficiary nomination form is. What we're going to be looking at, firstly, we're going to look at the fund death benefits. So that is the benefit that would be paid out to your beneficiaries in the event of your death. And then we're going to look at what options they would have when it comes to that death benefit. We're also going to look at the taxation of that death benefit. And then we're going to look at the role of the beneficiary nomination form. So why is it important in this entire process? We're going to look at wills as well, financial advice for members, and then lastly, we're going to be taking questions. So starting with the death benefit that you have in the fund. Now, this is the benefit that would be paid to your beneficiaries in the event of your death. And that benefit is your group life cover plus your fund credit. So your group life cover for Rhodes University would be 4 times your annual pensionable salary, and this is taxable, plus your fund credit, which is the money that you have in your retirement fund at that point in time. That would include contributions that you have made, contributions your employer has also made, less any risk and admin costs, plus investment returns, which can either be positive or negative. So basically, the fund credit would be the money you have at that point in time. That would be paid along with your group life cover. Now, those two benefits would be taxed according to the retirement tax tables. It is an approved life cover, which is why it would be taxable in the hands of the beneficiaries before they actually receive it. Now we're going to unpack the options that they would have at that point in time. The first option, the beneficiaries who qualify to receive that death benefit can elect to take the full benefit in cash. If they elect to take it in cash, that is when it would be taxable. The second option that they have, they can purchase an annuity that is going to provide them with a monthly income outside the retirement fund. So those are the two options. If they take cash, it will be taxable. If they don't take cash, then they can purchase an annuity and they can receive a fixed income for a particular period using that lump sum, which would be your group life cover plus your fund credit. Now, I did mention that it would be taxed according to the retirement tax table. Now, according to the retirement tax table, the first 500,000 that is taken in cash may be tax-free. I say may be tax-free because it would depend on if there were any previous withdrawals that were made by the member. Any previous withdrawals made by the member reduce that tax-free portion of 500,000. So if there are no previous withdrawals from a retirement fund, then they would still have that 500,000 tax-free portion intact, and it would mean that any amount that they are taking in cash that is below 500,000 would then be tax-free. Any amount above that would then be taxed on a sliding scale at either 18%, 27%, or 36%, depending on what the lump sum is. Now, on the next slide, we're going to look at an example of how the taxation would work, or how the amount would be taxed if the beneficiaries elect to take the benefit or the death benefit in cash. Now, let us say that this is a member that has a fund credit of 800,000. And they also have group life cover, which is equal to 700,000. Therefore, the full benefit or the full death benefit for this member that is payable to the beneficiaries would equal to 1.5 million. Now, let us say the beneficiaries decide to exercise the first option, which is to take the entire amount in cash. The total lump sum payable is 1.5 million. There is a tax-free portion of 500,000, therefore the tax would be 0 on that. However, there is still 1 million that needs to be taxed, and it would be taxed as follows. 500,000 to 700,000 would be taxed at 18%. Therefore, that is 200,000 times 0.18, which is equal to 36,000. And then the amount between 700,000 and 1,050,000 would be taxed at 27%. That amount is 350,000. Therefore, it would be taxed at 27%, making the tax payable 94,500. Now, the remaining amount after that. So remember, on that 1 million, we've already taxed 200,000 plus 350,000. So there's still an amount that is remaining that needs to be taxed. Now, that remaining amount would be taxed at 36%, making the tax payable 162,000. Therefore, the total tax that would be payable on 1.5 million if the beneficiaries elect to take the lump sum in cash is 292,500, making the net benefit that they would receive 1.2 million. That is how the taxation works when the beneficiaries are receiving that death benefit in cash. It is paid to them after tax has been deducted. It's not the full 1.5 that they would receive. And then also going back to the tax-free portion, if the member had made any previous withdrawals on a retirement fund, then that would be taken into account when it comes to that tax-free portion. And that means that actually the tax liability would also increase because that tax-free portion would be reduced by previous withdrawals. Now, let us say the beneficiaries decide to exercise the second option, which is to purchase a pension. Therefore, they're not taking any cash. They are simply using the amount to purchase a pension. Now, again, the total lump sum payable is 1.5 million. Tax-free amount is 500,000. Or let's say they decide that they're going to be taking 500,000 in cash, and then the 1 million, they're going to be purchasing a pension. So 500,000 is tax-free because there's no previous withdrawals that were made by the member. And then the balance of that amount is a tax-free transfer that they're going to use to purchase themselves a pension, which is going to give them an income or an annuity for a particular period or for life. Tax payable would be 0 because they decided to take cash, which was within that tax-free portion, and then the rest of that amount, they simply transferred to purchase a pension or an annuity. Therefore, the net cash received is 500,000, and the tax-free transfer is 1 million. Therefore, the benefit due to the members is still 1.5 million because they haven't paid any taxation. The beneficiaries haven't paid any taxation because they received the 500,000 in cash, tax-free, and the 1 million was also a tax-free transfer to purchase a pension. Therefore, the total benefit due without any taxation is 1.5 million. Now, taxation can be a very complicated or complex subject. So if you have any questions, please post them in the chat box and Nikki will be able to assist you with that. Now, let's go to how this death benefit is paid out. It is paid out according to Section 37C of the Pension Funds Act. And according to Section 37C, the trustees must use their own discretion when paying out this benefit. They need to consider the beneficiary nomination form as a guideline as to who are the beneficiaries of this death benefit. And also they have the final decision. The benefit you have in your retirement fund will not be paid out in terms of the will. They only look at your beneficiary nomination form. And the trustees need to consider all dependents. When we say dependents, we mean someone that was financially dependent on you. It can be a legal dependent, such as your spouse or your kids, or it can be a factual dependent, which is someone who is not legally dependent on you, but they were dependent on you financially for their day-to-day survival. If there is such a person, then they would be considered as a beneficiary because they were financially dependent on you. And like I said, they have the final discretion. Now, this is to protect people who are financially dependent on you. It's not to put you in a negative position, or it's not to say that they won't go according to your wishes, but it is there to protect those people that are financially dependent on you. And also, it is your responsibility as the member of the fund to ensure that you've included all your dependents on that beneficiary nomination form, and also you keep it updated. Anytime you have a life-changing event, you keep it updated. Let us say you get married, you get divorced, you have a new child, or someone that you nominated years ago when you joined the company has now passed away. Please ensure you update that form, because if it is up to date, then it makes the process quite easy for the trustees and also for your beneficiaries as well. If the form is not up to date, then the process of paying out that benefit can take up to 12 months. Now, if you are the sole provider in your family, or if you are the breadwinner, it means that they might be without an income for a period of 12 months while the trustees are still doing their investigations to find out who were your financial dependents. It is absolutely confidential. The form will be kept on your personal file and will only be used to distribute the death benefit. So please ensure you keep those forms up to date. They do not consider your will, because your benefit that you have in the fund, which is your death benefit, it's not paid to your estate. They have to look at the beneficiary nomination form. So please ensure those forms are up to date. You can get the form from your HR person. Once it's completed, you hand it back to them for safekeeping. You can also update the form on AF Online. But for those members that were on the pension fund and then they transferred, they may be able to update the form by the end of May on AF Online. But it's always recommended that if you update on AF Online, please also update with your HR person so that they have the same information. Now, going to dependents, as I have mentioned, you can have legal dependents or factual dependents. Now, the legal dependents is people that you have a legal duty to support. That would include your spouse, your kids, irrespective of their age, your parents, your grandparents, unborn, adopted, and also illegitimate children. Those would be considered as your legal dependents in terms of Section 37C of the Pension Funds Act. You then have your factual dependents. Those are people you don't have a legal duty to support, but they are financially dependent on you for their day-to-day survival. This may include, but also it's not limited to, relationships where there is mutual dependency. And then you have your nominees. Now, those are people who are not your legal dependents, also not your factual dependents, but it is people that you would like to receive a share of your death benefit, but they are not your legal or factual dependents. So if, for instance, you are someone who doesn't have a spouse and doesn't have any kids, you can then have nominees, which would be people that can receive the benefit on your behalf should you pass away. Now we're going to look at the role of the beneficiary nomination form. I think we've already highlighted the importance of the beneficiary nomination form and why it needs to be in place for your death benefit to be paid out to your beneficiaries, and also how it helps in ensuring that the process is not time consuming for everyone who's involved, whether it's the trustees or the beneficiaries, because if it's up to date, then it can be paid out quicker to your beneficiaries. Now, the requirements for expression of your wish is your ID document of the dependent or nominee that needs to be attached, because this provides proof of dependency. A marriage or tribal union certificate for customary marriage also would need to be attached. It includes all biological children, regardless of age, and whether maintenance is paid or not. If you have a legal duty to support that person, then they would be considered as a beneficiary in terms of your death benefit that you have in your retirement fund. Now, let's look at the will. The will is also, like I said, very important in terms of paying out your assets or distributing your assets to your beneficiaries. But what's important to understand is that your will is not taken into account, or it's not considered when it comes to paying out the benefit you have in the fund. So this is just to ensure that you don't get confused. When it comes to your death benefit in the fund, they use your beneficiary nomination form. But when it comes to your assets outside the retirement fund, they then consider your will. If at a point in time, when the trustees are doing their investigation, let us say that your beneficiary nomination form was not up to date. If they can't find any beneficiaries to pay out the benefit to, then the benefit may go into your estate. Now, when it goes into your estate, that is when it would be paid out according to your will or your last testament. But if there are beneficiaries that are found, then it would be paid out according to your beneficiary nomination form. The only time it goes into your estate and it's paid according to your will, then it is when they can't find any beneficiaries that can receive the benefit on your behalf. Now, a basic guideline you can use for yourself when it comes to nominating beneficiaries is to assess your situation. Who are your dependents? Who are you liable to maintain? Who do you support financially? Because all those people would be regarded as beneficiaries, and you have to list them on that beneficiary nomination form. Update your form on a regular basis. There is no limit in terms of how many times you can update the form. If you have a life-changing event, if you need to update the form for any reason, you can do so. And when you update the form, you include all those financial dependents, because this will prevent the delay in payment, as I have mentioned. Now, going to wills and the importance of wills. Now, a will is absolutely essential if you are over 16 and you own assets such as a house, furniture, car, savings, etc. There is a misconception that people who need wills are people who are well off or people that have a lot of assets. That is not the case. If you are over 16 and you have assets and you would like your assets to be distributed in a certain manner, then you can have a will. Also, if you want to provide instructions, let's say nominating a guardian for your kids, you can have a will. So a will is absolutely essential if you have assets and if you want to distribute those assets as per your wishes or to nominate a guardian. If you do not have a will and you pass away, then the state would divide your assets as per Interstate Act. So if you pass away without a will, Interstate Succession Act would apply. In that case, it means that your heirs can actually be disadvantaged, because the Master of High Court would be the one who has to appoint an executor to actually dissolve that estate. And in that case, then your heirs may be disadvantaged. But if you have a will in place and it is valid, it means that your assets will be distributed as per your wishes. Now, looking more into the Interstate Succession Act, the Master of High Court would appoint an executor to wind up your estate. And the Interstate Succession Act will be used to apportion the distribution of the assets. Now, the executor may not be a family member, but will still cost the estate 3.5% plus VAT. If your wishes are not in writing, they cannot be taken into account. And unfortunately, when you are not here, there is no way you can have a say in how those assets can be distributed. If you have minors or if you have heirs, then they may be disadvantaged at that point because you didn't have your wishes in writing. We're going to look at how the assets would be distributed in terms of the Interstate Succession Act. Now, this is an example of a deceased that is survived by a spouse as well as descendants. Now, spouses, in terms of Interstate Succession Act, would inherit greater of 250,000 or the child's share. How do they calculate the child's share? They divide the interstate estate by the number of their surviving children, plus deceased children who have descendants, plus surviving spouses. That is how the child's share is calculated. And then, of course, the spouse would inherit greater of 250,000 or that child's share that has been calculated. If the estate is under 250,000, then the spouse will inherit, or the spouses will inherit in equal shares, while the descendants will not receive anything. So as you can see, the heirs can be disadvantaged if the Interstate Succession Act applies. Now, going to our example, let us say the deceased is survived by 2 spouses and 3 children, and they have an estate that is worth 1.5 million. The child's share would be calculated by dividing that 1.5 million by 3 children plus 2 spouses, which is equal to 5. Therefore, it would be 1.5 million divided by 5. Therefore, both spouses would then receive 300,000, which is the child's share. And each child would then receive 300,000. So how it is done is, to make it simple, it's 1.5 million divided by 5, which equals the child's share to 300,000. 2 spouses survive the deceased. They each receive 300,000 of that 1.5 million. The remaining amount is then divided equally according to to the children, which is 3, which means a child then receives 300,000. So in this case, it seems quite fair because everyone involved received 300,000, but that is not always the case. As we have seen, if the estate is under 250,000, the spouses that are surviving the deceased would inherit in equal share, and the descendants would not receive anything. But in this case, everyone received equal payments of 300,000. That is how the Interstate Succession Act applies. If you have any questions on this, because again, it can be a very complicated subject, please do post those questions in the chat box. How do you draft a will? Firstly, you have to draw up a list of all your assets, everything that you own or everything that is in your name, such as your house, your car, your furniture, your savings, your policies, etc. And then determine the value of these assets. After that, you draw up a list of your liabilities, things that you still owe or things that you still need to pay, such as your bond, your outstanding debt, your credit card, etc. You then decide on an executor. It can be more than one person. At least one of those people should be an institution, some like a bank or a trust or company, because it has to be someone who understands the legal requirements of drafting a will for it to be valid. So one of those people should be an institution. This will also help in simplifying the process if an executor has already been appointed. Now, a will covers all of your assets, like I've said, except your retirement funds. Your retirement fund is paid according to the Pension Funds Act, as we have seen in the previous slides. The will only covers your assets outside the retirement fund. Now we're going to be looking at the legal requirements for a will to be valid. It is the signatures. It must be signed by yourself and 2 legal witnesses. You must sign in each other's presence. You must sign in each page. The witness must be over the age of 14 for the will to be valid. Any beneficiary or spouse cannot be a witness on your will. Executors, trustees, or guardians also cannot be a witness. Those are the legal requirements in terms of the signature. A few tips to ensure that the process is simplified and also not time consuming, and to ensure that your will is valid. To avoid any complications, it's important to keep your will very clear and also simple and easy to understand for the next person that's going to be reading that will or that's going to be working with that will. Also, it's important to always know where your will is situated. It must be reviewed on a regular basis because there's life events that, okay, you get married, you get divorced, you have another child, someone that you maybe listed on your will to receive a certain asset has now passed away. So you have to constantly review your will so that you can update it if you need to. You also have to ask yourself the question of, do you need a trust to protect minors? If you do need a trust to protect minors, have you spoken to the relevant people, such as a financial planner that can assist you in that regard? Also, your will should be drafted by someone who's competent in the tax and legal environment, because they will ensure that your will is valid and all the legal requirements have been met. Be sure to keep your beneficiaries updated on life policies as well, because they fall outside the will. Now let us look at wills and divorce and see what happens after you divorce and you have not updated your will, or what time frame do you have to ensure that your will is updated after a divorce. So if the testator no longer wishes for the ex-spouse to benefit from their assets, then they need to revoke the existing will within 3 months of date of divorce. If the testator then dies within 3 months of divorce, a will that was executed prior to dissolving that marriage will be implemented as if the ex-spouse had died before the divorce. Therefore, they will not inherit. However, if the existing will is not changed and the testator dies more than 3 months after the divorce, the testator's ex-spouse will then inherit if he or she was a beneficiary in that will. So in simple terms, you have 3 months to ensure that you update your will after your divorce if you wish for your ex-spouse to not inherit should you pass away. So if the testator no longer wishes for ex-spouse to benefit, they must revoke the existing will. Hopefully that is clear for everyone and easy to understand. If you have any questions, please post them in the chat box. But basically, in simple terms, after a divorce, you have 3 months to revoke existing will if you no longer wish for your ex-spouse to benefit. Again, it's important to ensure that your will is done correctly, because once you've passed on, there is no way you can express your wishes. Also, a few tips or important things to note when you are drafting your will. It's important to consult professional service. This will ensure that your will is done correctly. Also, Alexander Forbes can provide you with a free standard will as a member of the fund. They can discuss your customized needs as well. So if you want a complex will or a customized will, then there will be a fee that has to be paid, but they would advise you of the costs upfront. And if they do draft your will, then they would be the executor. However, for a standard will, it is absolutely free, unless of course it's a customized or a complex will. So if you do need a financial planner or a financial advisor, you can always use those contact details provided below. The telephone number is 011-269-2940, or you can email our fiduciary services at aforbes.co.za, or you can simply contact Alexander Forbes and they will get a financial planner to be in touch with you to assist you with setting up your will. You can also take a screenshot or a picture of the contact details if you may need them to use them later to be able to get assistance in terms of drafting a will. But it's important to note that if it's a customized or a complex will, then there will be a fee, but they will advise you upfront of what the fee is. More important information, it's important, or it's your responsibility as a member to ensure that you understand your death benefits. You understand how it's going to be paid, and also you understand the taxation implications that come with paying out that benefit in cash. As we have looked at an example in the first few slides of what the taxation implications are and what options the beneficiaries have when it comes to paying out that death benefit. Keeping your beneficiary forms updated is also very important because it means that the process of paying out your benefits will be less time consuming, and also it will be less complicated because you have ensured that it's up to date. You have included all your dependents, and you have to also remember that it's all about financial dependency when it comes to your retirement fund. Who was financially dependent on you, whether it's a legal dependent or a factual dependent. Be sure you have an updated will as well for your assets outside the retirement fund. Choose an executor for yourself, but as I have mentioned, it may be a family member, but one person has to be an institution such as a bank or a lawyer, someone who's skilled in the legal and tax environment. Keep your will safe as well, so that it doesn't land on the wrong hands, and ensure that you meet the legal requirements for that will to be valid and executed after you've passed on. For more information to help you in terms of growing your financial well-being, we do have a My Money Matters toolkit. Now, the toolkit includes videos and brochures that can give you more information when it comes to options you have as a member when you join the fund, when you are leaving the fund, or when you are retiring from your employer, as well as any other money matters that can help you in terms of growing your financial well-being. We believe that if you as the members receive the right information at the right time, then you are able to make the right decisions. So this is what these sessions are for, to ensure that we are providing you with the right information so that in future, when it comes to your retirement fund, as well as any other financial well-being matters you have outside the retirement fund, you are able to make the right decisions. So if you have access to Wi-Fi or mobile data, you can find out more information regarding that toolkit on our website, or you can also contact us as Alexander Forbes. Again, you can take a screenshot or a picture of the contact details for that My Money Matters toolkit if it's something that you would be interested in. We also do provide you with individual financial planning advice for money management matters, for joining and leaving retirement funds, for retirement and investment planning, for tax and estate planning, and death and disability cover as well. For those individual financial planning advice, you can contact Alexander Forbes and they can assist you with a financial planner, or you can contact the My Money Matters Center on the details provided. Now, you are not obligated to use Alexander Forbes financial planners, but for those members who do not have access to financial planners, then Alexander Forbes can provide you with a financial planner. You don't have to pay a fee to receive that financial advice, unless, of course, during that session, you then decide that you're going to be taking up a financial product. Then there would be fees and they would advise you of those fees upfront. But to be able to have a one-on-one discussion with a financial planner, you don't have to pay a fee as a member of the fund. If you have any questions regarding the information that has been shared, please do post them in the chat box. Again, as a disclaimer, today's session is not to be taken as financial advice. It is factual information regarding your retirement fund. If you need financial advice, then you can always contact us as Alexander Forbes. From my side, thank you so much for attending this session and thank you for your time. This is our last session with Rose University, but it doesn't mean that it's the last time that you can engage with us. If you do have any further questions, please feel free to contact us anytime and we will be able to assist you. But I hope this was worth your time and attendance as well. And I look forward to engaging with you again in future. Nikki, I'm not sure if there are any questions in the chat box.
Thanks so much, Sinabasa. There is just one question that I haven't addressed yet. It's, do beneficiaries get charged upon the execution of a will? So the will be done via our individual department for members. As far as I'm aware, there's no charge for the execution of a basic will. Obviously, the more complicated it gets, the individual financial planner will engage with you if there is a cost. But from my understanding, there isn't a cost.
Thank you, Nikki.
I have addressed the other questions in the chat. If there is something somebody wants to ask further, if you could just pose it in the chat box. As I mentioned, the recording of the session will be uploaded on the Rhodes University Pension Fund Restructuring website. It does take a few days to upload. We also have provided all of the pension fund members who now belong to the Provident Fund with effect from 1st of April 2022, a manual beneficiary nomination form. Please, once you have completed that, please provide that back to your HR department and not back to me. Your HR division must keep that on your personnel file, as Sinabasa has mentioned. But this is the last of our information sessions, as Sinabasa has stated. We really enjoy doing them. This won't be the last of the sessions in total, but it's just the last of the sessions that has been arranged as part of the restructuring exercise. So we do look forward to engaging with you in future, and thank you so much for your attendance, and thank you, Sinabasa, for a great presentation.
Thank you very much, Nikki. Again, if there are any questions, even after this session, then you can always just contact us if you need to ask anything or if you need clarity on information we've shared, or if you need to get in touch with a financial planner.
Thank you, everybody.